All right. Well, thank you all for being here at this GCP conversation. This is the second one for the 2025 fellowship class. So, for those of you who are not in attendance last month, welcome. This program, the GCP Conversations, it's an important way for us to provide ongoing formation, both intellectual and spiritual, to our fellows and our other allied attorneys. And it's good supplemental formation where we can be a little bit more varied than the GCP seminars that are the core of our fellowship or the Great Book seminars, but this gives us a little bit more leeway to cover different topics and areas of formation for the lawyers who are working with us. So thank you all for being here. And this month we're very grateful to welcome Professor Richard Garnett from Notre Dame Law School. Thank you for being here with us. So before I begin, just a quick housekeeping couple of items here. So the conversation will begin with brief opening remarks from Professor Garnett, then we'll do a kind of fireside chat back and forth where we'll talk about some of the pressing issues of on the religious liberty front, things pending in the Supreme Court, the next battles to come, and so on. And then, as usual, we'll try to leave time for participant questions at the end. So I'd ask if you have questions. Obviously, you can't speak because of the webinar format, so you can type them into the chat function or the Q&A function, and I'll be able to read and curate them as time permits. And this is being recorded. So if you miss part of it, or just so you know that you are being recorded, if that announcement happened before you got on, now you know. So, Professor Richard Garnett teaches and writes in the areas of constitutional law, criminal law, the First Amendment, and law and religion. He's a leading authority on questions and debates regarding religious freedom and church-state relations, and he's the founding director of Notre Dame Law School's program on church, state, and society. Professor Garnett clerked for the late Chief Justice of the United States, William Rehnquist, and also for the late Chief Judge of the U.S. Court of Appeals for the Eighth Circuit, Richard S. Arnold. He earned his JD from Yale Law in 1995 and his BA summa cum laude from Duke in 1990. Joined the faculty at Notre Dame in 1999 after practicing law in Washington, D.C. at the firm of Miller, Cassidy, LaRocca, and Lewin. And going off script here on the bio, and just wanted to highlight the excellent book that Professor Garnett co-authored, Religion in the American Constitutional Experiment. He did not ask me to say this, and he has told me that he actually doesn't really profit much by selling this particular book. So I'm plugging this because I've done some work on religion in the First Amendment, and it was an amazing primer on a lot of the precedent, but also the legal backdrop of religious liberty, especially before the Constitution was ratified. So it's a great resource. It's worth having. And Professor Garnett, if there's anything I can plug that will make you money, feel free to mention that at some point. So I will stop talking and I'll let you begin your remarks. So thank you so much for being here.
Well, it's thank you. It's a real privilege to be with you and to be with the Napa program. I'm a big fan. Um, I think the best use of our time is going to be the fireside chat and the questions, but I did want to say just a few things to kind of frame the discussion and maybe let all of you know some of my priors and where I'm coming from. Um, as it happens, although Frank and I didn't plan this, these are just three quick points that do kind of come out of the opening chapters of the book that you kindly just mentioned. So here's just a few things about the American approach, the American experiment, we call it, in religious freedom under law. That is, using law, operationalizing religious freedom through law. America took a distinct approach, and it's an approach that I think is, generally speaking, a sound one. It's one that faces some challenges, but at the same time, it's one that I continue to believe is one of the better ones on offer if you look around the world. So here's a first point. We need to think about religious freedom not as a concession granted by governments, but as a fundamental human right that is acknowledged and respected by governments. The idea is it's not a gift, it's not a present from the state. Religious freedom properly understood is the state recognizing the limits on its own authority, the limits on its own kind of jurisdiction, if you will. A state that does that, that is, that acknowledges that its own remit is limited, is going to be a state that better protects religious freedom. So we need to always be in that mindset that to understand religious freedom well is not merely to ask for favors from the state. We use the word accommodation a lot, and it's fine to use that word. We use the word toleration a lot. It's fine to use that word. But at the end of the day, religious freedom is a fundamental human right. That's point one. Point two, I want to suggest when we think about the American constitutional experiment, there's a risk that we focus too much on a few thinkers, obviously very significant thinkers, but on a few thinkers who don't represent the entire span of the debate that was going on at the American founding and that's continued throughout our history. So, we all, when we think about religious freedom and study religious freedom law, we hear about Thomas Jefferson and his letter to the Danbury Baptists and the Virginia Statute on Religious Freedom, and James Madison. We hear about the memorial and remonstrance that he wrote attacking Patrick Henry. Very important thinkers, very important documents, very important episodes, but not the whole story. And um, in my view, when the Supreme Court has gone wrong in our history, as it sometimes has when it comes to church state relations, it's often because it overemphasized a few statements and lines from writings of Madison and Jefferson and neglected some of the other voices that were very powerful at the time of the founding. Uh, to name just a few, there's a group we could call the Civic Republicans. I think of George Washington as being someone in this camp. Um, People for whom uh, religion, even if they weren't necessarily pious or devout themselves, religion was seen as a crucial component of our experiment in Republican government. That religion was necessary to create the kind of virtuous citizens that we need. Right. Again, there's a tendency sometimes to overlook this school, to focus only on Madison, Jefferson, on people who we label as deists or Enlightenment philosophers, people who maybe tolerated religion but kind of hoped it was going to wither away at some point. There were people like that, but they were not the only people, and in my view, they weren't even the dominant people. Another camp, just to highlight, the American Revolution grew out of a lot of kind of evangelical religious fervor. That is, we had at the time of the founding, the Revolution, and then after, also in the founding, um, people whose political theory, right, their theory of democratic constitutionalism, was very much work um, uh, informed by their views about religious evangelism and revivalism. So I have an ancestor a long, long time ago who was imprisoned in Virginia. He was a Baptist sort of dissenter from the establishment at the time, for preaching without a license. And folks like this who rebelled, against these kind of early establishments, it wasn't that they were secularists, but they were pretty fired up, not only for revolution, but also for religious freedom. So my point here, this is point two, is just to appreciate that the American constitutional experiment in religious freedom emerges from a conversation that included more speakers than just Thomas Jefferson. And then here's the third point. I'm sorry, I'm going on too long. There's there's a tendency sometimes in law generally, but especially in constitutional law, I think, for people to look for kind of one principle that will explain everything. It's like Lord of the Rings, one ring to rule them all, or something. So in church state law, sometimes people will say, well, it's all about separation, or it's all about neutrality, or it's all about equality. The fact is, there's a lot of important principles that are often in balance, and some come to the fore in some contexts and some recede in others. So our law of religious freedom has been shaped and animated by commitments not only to freedom of conscience, denominational equality, but also, a kind of a non-establishment principle, um, not an aggressive French Revolution type secularism, but a sense that the that separation of religious and political authority is a good thing. Um, Neutrality has been an important theme in the court's doctrines, which doesn't mean that the court's supposed to be, or governments are supposed to be hostile to religion or indifferent to it even, but neutrality as between different religious groups. This is part of our experience of pluralism. So that's my third point. More than one principle. And with that, Frank, I think I'll talk to you about whatever you want.
Great, thank you. That's a really helpful way to frame the conversation. So, actually, the I'm going to go a little off script with the threshold question because I think it's of interest to a lot of the people listening, and I think it's kind of an important starting point given the whole free exercise jurisprudence that we've been dealing with, especially since Employment Division versus Smith. So, I think there's a fair amount of baseline knowledge among our attendees, but just as a backdrop, the Employment Division versus Smith case that effectively narrowed or depending on how you view the proper interpretation of the free exercise clause, but held that, right, if a law is neutral, generally applicable, it's not targeting religion or a particular religion, then you don't get strict scrutiny protections if that law burdens your religious exercise in
Right.
practice. Is that about right?
Yeah.
So my question is there's a movement, and I don't know how much steam it has, but there's a line of thought from even more like originalist or religious liberty friendly people that's not all that wrong, that maybe the religious exercise clause was meant to be kind of a limited, like, don't target a particular religion, that's about the extent of it. And that's, I guess I'm curious to hear your thoughts on, for one, what you think the proper interpretation of religious exercise in this sphere is, because for one, there's a lot of movement to try to overturn Smith, and that's I think brewing and potentially on the table in the coming years. But also, if that interpretation of the free exercise clause, very narrowed, is correct, then there's a practical problem in that um, in the era when the Constitution was enacted and everything was ratified, you didn't have the kinds of laws that were infringing on religious practices that we have now, non-discrimination laws and so on. So I know that's kind of a broad question or series of questions, but anything you want to comment on there?
Well, you've really hit what is kind of the most interesting and challenging question in the whole field. So let me say a few things about it. Um, a first thing, and I apologize if this sounds kind of simplistic, but I really do think it's true. It's that um, if we think about religious freedom as kind of a project, right? We have a pluralistic society. We have governments that do stuff. We have governments that do stuff that sometimes religious people have religious reasons for resisting. How are we going to navigate this, right? Um, the religious freedom challenge is really easy when everybody agrees, because then their political process will just kind of map nicely onto what people's religious needs are. And it's really easy when governments don't do anything, because then you don't have any conflict, right? So we are in a situation where we have governments that do a lot of stuff, and we have religious diversity. We have a lot of different religious traditions, and we have people who understand their own traditions differently. So the point to your question is that the conflict between government requirements, general, neutral, otherwise valid laws on the one hand, and the religious consciences of some people, those conflicts are unavoidable. So, what are we going to do about it? One potential answer is, which I think of as kind of the secularist answer, is to say we don't do anything about it. We ignore that. Uh, that's not the. There's a certain understanding um, of secularity, of church-state separation, that says that that's not the government's business. Government passes a law, everyone obeys the law. Period. Do your best in the political process. If you lose, you lose. Another possible solution, but it's one that I have to say I don't think is realistic, um, or operationalizable, is to say anytime you object for religious reasons to complying with the law, you don't have to. So we can't do either of those. So what's going to be our via media, if you want? And this takes us to your question. Um, uh, for about 30 years, between the 60s and the early 90s, the Supreme Court's position was that if a government action substantially burdened the sincerely held religious beliefs or religious exercise of a person, that the government had to justify that burden by satisfying strict scrutiny. Pretty demanding standard. Um, that rule, which came out of a case called Sherbert, was kind of a piece with what the court was doing in other areas. Emerging free speech jurisprudence and emerging anti-racism jurisprudence and so on. Um, I'm of I'm in the camp, which I realize is kind of I'm in the minority among a lot of my friends in the religious freedom world. I actually don't think that Sherbert rule could be justified on originalist grounds. Um, so I think Smith, in a sense, is the right answer, by which I mean, um, if a law is non-discriminatory and otherwise valid, generally applicable, non-discriminatory, that claimants don't have a constitutional right to an exemption. Now, the crucial footnote to that is to appreciate that for our entire history, our governments have been pretty generous with religious accommodations. There are exceptions, obviously. You think of the LDS Church and polygamy and those fights in the late 1800s, um, other fights in the 20th century, to be sure. But from the very beginning, the debates about accommodating Quakers by not requiring them to engage in military service, we always understood that sometimes it was appropriate to accommodate religious believers, even when we were talking about laws that were otherwise valid and generally applicable. The fight in Smith, in my view, is not whether or not Justice Scalia liked religious freedom. I believe he did. It's about which actor is going to be in charge of engaging in the line drawing and the balancing that is always going to be involved. And the Smith answer is, generally speaking, it should be the legislature. And interestingly, after Smith, we got the Federal Religious Freedom Restoration Act. We got a whole bunch of states enacting Religious Freedom Restoration Act type laws. And a lot of scholars believe, and I'm sympathetic to this view, that we actually ended up with a more robust religious accommodations regime coming out of the legislature than we had before Smith. So you cut me off whenever I'm going too long winded. Where are we now? Now, what's really interesting, we saw this in the COVID cases, we've seen this in some other disputes about vaccines and other things. Um, we've seen the court, even after Smith, adopting a position that says, look, we're going to look really hard at government action to make sure that it's actually neutral and generally applicable. If the government wants the benefit of the Smith rule, it has to enact laws that really are, in fact, neutral and generally applicable. So in COVID, we saw laws, think of the ones about gatherings, religious gatherings, and so on, that didn't exempt churches, but they exempted casinos and liquor stores and other things. Those laws weren't generally applicable, and therefore I think it was entirely appropriate for the Supreme Court to apply close scrutiny to those closings because the Smith assumption of a general, neutral, generally applicable law wasn't present. Now, today, as you pointed out, Frank, there are a lot of scholars and at least three justices who think that we should overrule Smith. I think the question that my former colleague Justice Barrett asked in her opinion recently in the Fulton case is a good one, though. What do you intend to bring back? If one is an originalist, I don't think it's plausible to say, well, we'll just bring back the 1960s Sherbert test. So, what should be the legal rule? And that's something that I think all of us who are in this field are going to keep our eye on.
That's really helpful. Thank you. I think starting with these more general, like philosophical questions, and then we'll hone in on some cases is probably a good way to go.
Sure.
So I was going to use the Wisconsin Catholic Charities case here as a springboard into this other bigger picture question. But I mean, that's for those who don't know, that's a statutory interpretation case, but it does touch on the definition of what is or is not religion or religious. So I think it's a nice pretext for me to use a headline to talk about an issue that I want to touch here. So, I
Yeah.
mean, this is a pet issue of mine too, so I'm selfishly taking the time to bring it up, but I think it's relevant for the religious liberty movement that in First Amendment jurisprudence, no matter where you come down on like how broad the free exercise right is or not, I see that there's an issue with us not having a coherent original meaning definition of what a religion is, and I don't think there was a problem for most of American history, right? From the founding through like Reynolds, right? The polygamy case in the late 1800s. It's religion or the duty we owe to our creator. It involves some kind of duty of worship and morals to the creator, and that's about all that we had to say on the matter. And then we had this line of cases involving like a lot of it is conscientious objectors. You have like Torcaso and then Seeger, especially in the middle of the 20th century, where now we replace like a kind of theistic parameter, however specific that wherever the lines end up, to this like multi-part test where nobody's really sure what a religion is. And I think to me it's a big issue because if especially if we are continuing to broaden religious exercise rights and if Smith got overruled, I think this becomes even more important if you go back to a Sherbert test. Is like, well, okay, if we have this strict scrutiny analysis, anytime a neutral law is burdening religion, what's a religion? And I think he didn't write about it, but I would forgive Justice Scalia if this was a little in his mind during Smith, where it's like, well, we're giving these broad, strict scrutiny protections for like peyote smoking people who claim it's religious, or when it's drug users that are claiming religious worship rights. Um, so I'll return here to my question. But do you think that this is something that, for one, it's important for the religious liberty movement? Do you think there's work to be done to get to like an originalist definition of religion? And do you see a way in which that actually happens in the coming
Yeah.
years?
Well, you did it again. This is a hugely important question, and I know you've worked on it, and you kind of you kind of said for me a lot of what I would say. But again, just to kind of frame this, so all the listeners kind of see why this matters so much. We have a constitution that protects the free exercise of something, and that prohibits the establishment or prohibits laws respecting an establishment of something. It's one word, both of those somethings. It's religion, and that is nowhere defined in the Constitution. We also have, as we sometimes forget, a prohibition on religious tests in the original Constitution. Again, religion's not defined. Um, I think you're exactly right, Frank. That the founding, they didn't lose a lot of sleep about this. They knew it when they saw it. Um, you've got the kind of statement that Madison gives in the memorial, and that's also in the Virginia Declaration. The duty we owe to our Creator. Um, that's thought by some to be problematic in insofar as it's focused on duties and insofar as it's theistic. But it's pretty clear. For most of our history, this didn't cause courts much trouble. Again, they know it when they see it. America was pluralistic compared to most countries, but it was still pluralistic within kind of boundaries, right? Different kinds of Protestants, we know what they look like. Catholics, the founders were obviously familiar with Jews and Muslims and so on. Um, but it's more complicated now, right? Religious studies people and theologians fight about this all the time. What exactly is a religion? What's the line between religion and culture, religion and morality, religion and conscience? I think there's a lot of scholars who would say that the category of religion is kind of a bad fit with some traditions like those from the Indian subcontinent, or is Confucianism a religion? Is it something else? Is secular humanism a religion, or is it a non-religion? Um, I'm a Duke Blue Devils fan. Is that a religion? Who knows? Um, Generally speaking, courts have not wanted to get into this, at least when it comes to religious exercise claims. Generally speaking, what courts have done is, instead of asking whether X is in fact a religion, they've asked whether the particular claimant is sincere. So courts have found it easier to ask about sincerity than to ask about this kind of um, anthropological question about what counts as a religion, because obviously courts are familiar with the concept of sincerity. We wonder whether people are lying all the time. So we focus more on, are you accurately telling me what your mental state is? And we focused less on, is that really a religion? I suspect, I don't hope this doesn't sound cynical, that sometimes when courts don't think that a particular claimant's religion is actually a religion, think of prison cases and some of these tax evader cases, and the flying spaghetti monster, or perhaps the Church of Satan in some of these recent cases where it looks like what they're doing is just trolling. Um, Courts use sincerity as a way to get around the definitional problem. But I think you have pointed to a really important challenge, which is, if we try to imagine moving away from Smith, and if we try to imagine making it easier for claimants to get to strict scrutiny, at the same time that we have huge religious pluralism, and we're also kind of not willing to draw lines around what counts as a religion, we're going to end up with some disingenuous judicial opinions. That is, strict scrutiny cannot function if there's not some inquiry into what actually counts as a religion. This is true, by the way, in the free speech context too. What's speech? We expanded it to conduct, to expressive conduct, to dancing, to you know tattooing. All these kinds of things count as speech. one of the concerns we might have about if you expand the definition of the thing you're protecting, you're going to end up providing less protection to it. So I think for us, a real challenge going forward is to simultaneously embrace the reality that we have religious pluralism
Mhm.
while not watering down the definition of religion so much that we end up with a unable to provide meaningful protections to kind of the core. Some other jurisdictions around the world, they've they don't use the term religion. They just talk about protections of freedom of conscience or belief. That opens it up really, really wide. And if you study, the kind of conscience and belief jurisprudence from a lot of the European countries, for example, what you see is there's not a whole lot of protection provided. Um, Justice Hugo Black, who had some problems when it comes to church-state relations, in my view, um, he was able to be an absolutist on some of these fundamental rights, but it was usually because he defined the right pretty narrowly, right? Think of the Fourth Amendment, think of the Fifth Amendment, think of the Sixth Amendment. If you define the rights more narrowly, you can provide more protections to them. The same is true in the religion context. So this is a long-winded way of affirming exactly what you said, which is we don't have a definition, and that's going to pose some challenges for us going forward.
Do you think, just a quick follow-up on the practical, because if there were, a case that would go up and offer, right, the opportunity for the Supreme Court to kinda hone in on a more coherent originalist or properly narrowed definition of religion, can you see difficulties in finding the right case, especially in the wake of Smith, where neutral, generally applicable laws are um, not really treated as First Amendment challenges anymore? They get challenged under state RFRAs or they get challenged on under other grounds. So how do you even bring a case that's going to address this? It's fine if you
Yeah.
haven't thought through that.
Well, no, I mean, I won't pretend to have solved it, but I try to think about it a lot. I mean, let's just think of the Federal Religious Freedom Restoration Act or the companion statute, the Religious Land Use and Institutionalized Persons Acts. Those are statutes that provide special protections for religious claimants. So these aren't constitutional. You don't have to even worry about originalism. You can just, this is a statutory term. It has to have some boundary. The IRS has to be able to administer a tax code that provides exemptions for some kinds of entities and not others. We have to do some definitional work. Now, I think with statutes, it gets a little easier. And this is going to the case that you pointed to, the Wisconsin case that's before the court this term. Um, the risk is if we define for legal purposes, if we define religion in such a way that is itself discriminatory among religions, right? That's the worry. That's the issue in this Wisconsin case is that um, the challengers are saying that the state adopted for purposes of its statute, it adopted a definition of religion that was kind of inherently discriminatory. That it sort of presumed that in order to be religious, you have to only minister to co-religionists, and it basically codified a kind of Sunday morning only understanding of religion rather than one that's evangelical or ministerial. Um, so that's a problem. I mean, we would worry, I think, even if it's true that the vast majority of people at the time of the founding, insofar as they were religious, were some kind of Protestant Christian. Um, I think a lot of people, even originalists, would be uncomfortable with a constitutionalized definition of religion that said only only the following are religions: Christianity, Islam, and Judaism. Now, as an original matter, maybe that was kind of what people had in mind. Um, but I think that's not really a live option for us now. But I do think there's going to have to be some definitional precision going forward. I suspect it'll start in statutory cases rather than constitutional ones, because in statutory cases you can fine tune things a little more. In a way, this is an advantage of the post Smith era, because if courts get it wrong, legislatures can respond. This is assuming we have legislatures that are actually legislating, which I realize isn't really true these days. But um, I think we're going to get more progress on this definitional question you're raising in the statutory context than we will in the constitutional one. I think there's going to be a lot of nervousness about constitutionalizing a definition of religion.
Interesting. Yeah, I follow this one really closely, so maybe we'll get to revisit this in the next couple of years and see what's
Yeah,
happened.
yeah,
Now I want to move into some of there's a lot pending before the Supreme Court. There's a lot of interesting religious liberty stuff, a little bit more specifically on the ground here. But before we get to some of the things that are pending, I want to touch on one that's no longer pending. So the St. Isidore case, right? The Oklahoma virtual Catholic school versus Drummond. This we got an early decision. It's a couple
R.I.P.
seconds long and it's done. Um, so I guess I'm curious for one if you have any comments on the establishment clause, free exercise clause issues that were, I mean, at play from Trinity Lutheran to Carson v. Macon, and then we thought maybe we're going to keep moving with this case and are not. And then if you want to weigh in practically, I'm curious to hear whether you think we're just going to see a replay with a another school that doesn't involve Justice Barrett having to recuse herself. So take that
Yeah.
how like.
So just for the full disclosure, the Notre Dame Law School Religious Liberty Clinic was involved in this case,
Right.
represented St. Isidore. Um, I didn't, in my own capacity as a lawyer, represent the school, but I was pretty closely involved, as was my wife. Uh, I'll confess I was pretty invested in the case, and I think the court got it wrong. Um, Maybe this will be helpful. 99.9% of the coverage of this case misrepresented what the case was about, not necessarily on purpose. A lot of people thought that the question was, can we have a government run Catholic school? Can we have a Catholic public school? Um, that was never what the case is about. So, from St. Isidore's perspective, anyway, it's a non state school that was seeking to participate in Oklahoma's charter program, which, in St. Isidore's view, was really like a school choice program. It was like a voucher program. Lots of non state entities run charter schools around the country. Lots of non state entities grant charters. So the first mistake that a lot of people make is, and this is true of some states, by the way. In some states, a charter school really is just a government school that has like a particular theme or something. But in some states, a charter school program it's a request for proposals and contracting program. So St. Isidore's view was that yeah, it's a Catholic school. It's not pretending not to be a Catholic school. And yeah, the government is going to pay for kids to get an education at a Catholic school. But the government pays for kids to get educated at religious schools all the time. Um, you know, whether it's Notre Dame or whether it's, the parochial school down the street in a school choice program. It's been established for decades now that the Establishment Clause permits government to grant scholarships to kids who are attending religious schools. And as you pointed out, you mentioned Trinity Lutheran and these other cases. It's become pretty clear in the last decade or so that once the government opens up a general benefit program and it's permitting non-state actors to participate in such a program, it can't discriminate against religious ones. And so St. Isidore's position was that it would be discriminatory to say, um, this private institution can participate in the charter program, but St. Isidore can't. Why can't St. Isidore? Because it's religious. That's discrimination in our view. So, in our view, the Establishment Clause would have permitted St. Isidore to participate, and the Free Exercise Clause required that St. Isidore be allowed to participate. Um, I don't have any inside information about, which justice voted which way. It was a tie. That means the Oklahoma law stands, or the Oklahoma decision stands, rather. It's not precedent anywhere. The Supreme Court did not. This is another mistake that the press made. The Supreme Court did not reject St. Isidore's arguments. It's as if it never happened. So Oklahoma has to live under some bad law, but it's irrelevant. So it would be totally fine if tomorrow 25 state governors said, you know what, we've decided that the St. Isidore lawyers were right, and we're going to let Catholic schools participate in the charter school program. They could do that, and I'm hoping that some will. Um, Another option is just for some other religious charter schools to apply for some charters, get turned down, and see what happens. And as you mentioned, Justice Barrett recused from this case. She didn't say why. She's not required to say why. I know there's a lot of theories about why it was, um, but it's it's inevitable that this issue will come back in a case where there are no recusals. And I think it's pretty clear on the Establishment Clause side. Zellman says it's fine to have school choice programs. On the Trinity Lutheran free exercise side, Chief Justice Roberts has been very solid on this. You can't discriminate against religious participants. So the key thing in terms of messaging is to help people understand that charter schools are not necessarily government actors. If they were government actors, you can't have a government run Catholic school. Everybody admits that. But if it's a private school that's just receiving public money, that's fine and it's allowed to be Catholic. So I'm hoping that, we'll get there in a couple of years on this issue, I think.
Yeah, I'm really happy that you clarified the messaging because the messaging on this case has been so poor, a lot of it inadvertently, like you said. But one thing that I correct me if I'm wrong, but I think makes it an even stronger case that Saint Isidore should have been decided differently is how similar in practice, it is to the situation in Carson v. Macon, which the Chief Justice wrote the opinion for, right? But the distinction that people were drawing, I think, is wrong. That in Carson v. Macon, which was the main, if you live in a rural place and you're not near a public school, you could get tuition assistance that could go to a private school. And the court held that excluding the religious schools as religious schools was a violation of the free exercise clause. So people that I had heard were saying that, well, this is distinct because that was tuition assistance per child in some cases, and then the parents were getting it and giving it to the school versus St. Isidore, the St. Isidore would just get this like chunk of money from the government, but to run a Catholic school. But if I understand correctly, that's not even true. That the money that flows to the charter program is per capita, right? So it's like
Exactly.
if only 10 kids enroll, there's only 10 checks.
Exactly. You're totally
Yeah.
right. The court has long since dropped the idea that there's some kind of magic significance to the money has to first come in the parents' hands and they have to walk it down the street to St. Cecilia's and hand it over to the principal. So it's all just bits and bots anyway. It doesn't matter. Um, St. Isidore only got money if a parent who was eligible decided to send his or her kid to St. Isidore. So it really is the same as a school voucher program in our view. Um, uh, is it regulated? Well, sure, but all private schools are regulated to some extent. So people acted like, well, this is different because St. Isidore's would be regulated because it's a charter school. Every school is regulated. Um, and they said, well, it's public because public dollars are being used to pay for it. Well, that again, Notre Dame couldn't survive without public dollars, for better or worse, and so that's not the issue either. And then there was an interesting argument that some smart law professor friends of mine made that I still think is unconvincing, was that this is different because the government created Saint Isidore because it was incorporated, but the Archdiocese of Chicago is incorporated, and so it can't be that simply by being incorporated you become part of the government. Um, so my line was always just because the state of Oklahoma contracts with FedEx to deliver some checks, it doesn't make FedEx part of the government. Um, the same should have been true here.
Great. I would love to just keep talking about Saint Isidore, but we'll move on in the interest of time here. One other case that I want to touch on, because I think it's an interesting interplay of constitutional rights questions, is that Mahmoud versus Taylor. So
Yeah,
I think pretty much everyone listening knows this, but the quick recap: this is the case where there's quite an explicit, sometimes sexual education curriculum being given to children, even in elementary school in Montgomery County, Maryland. The opt-out provision for parents was removed, and then we have this interesting case it's kind of it's a free exercise of religion case, but it's essentially a parental rights case. So I won't ask a particular question so much as just I'd be interested to hear your comments on this interplay of parental rights and religious exercise.
yeah, I think the Mahmoud case is fascinating. So there's a couple layers to it. One is the one you just mentioned, that you have a free action. It's like, which constitutional clause is doing the work? Is it the due process clause? Remember, parental rights are not explicitly in the Constitution. The parental rights come from the Pierce and Meyer back in the 20s. They're generally thought to be rooted in the due process clause, substantive due process. A lot of us are suspicious of that. It led to Griswold and Roe versus Wade and so on. So there's some questions there, but it also has free exercise. Um, we could go back to some famous cases like Tinker in the late 60s, which confirmed that public school children do have some constitutional rights when it comes to what's happening during the school day in public schools. Obviously, the school prayer cases stand for that proposition, right? Kids have a constitutional right to be free from religious coercion in public schools. Um, the Yoder case confirmed that parents have a parental right and a free exercise right to direct and control the education, the upbringing of their children. Great stuff. Um, Here's the challenge, though, is that you can't operate a government school system if every parent has a right to demand an opt out for their kid from a particular curricular item. It just can't function. Uh, and so this we're back to this balancing thing where um, if at some point, I think most of us think that kids who can't afford to attend private schools and therefore have to attend the government's schools need to have some constitutional protections from curricular practices that violate their rights. But again, at least in my view, maybe some of you all disagree. It couldn't be that every time a parent has an objection to a particular textbook or a particular reading or a particular curricular decision that the government has to justify it under strict scrutiny. They couldn't operate. Now, maybe the answer to that is good. Let's have just universal school choice. We could talk about that another day. Um, but I think in Mahmoud, the justices might have to address something that they've kind of punted on a lot over the years, which is um, to what extent really can we say that in the public school context, which again is it's run by the government and it has a purpose. Public schools have always had an ideological purpose. They were never neutral, despite what we might say. Um, the point of public education is to produce a certain kind of citizen, and and it's contested what that means, right? So in Montgomery County, people thought, well, it's really important to create the kind of citizens we want that we have these sexually explicit books for kindergartners about gender identity. And a lot of parents are like, well, no, we actually don't think that's part of being a good citizen, and it's certainly not part of our religion. And these are parents who don't have the option of private schools. So I'm curious to see first whether the court separates out the parental rights issue from the free exercise issue, whether it focuses just on the one, whether it talks about this hybrid idea that surfaced in Smith and then kind of went away, and everybody's kind of embarrassed about it. Um, and I'm interested to see, because remember, in this issue, in this case, Frank, the lower court said there's not even a burden here. They didn't even get to strict scrutiny. They just said there's not even a burden here because being exposed to ideas doesn't count as a burden. Well, they're going to lose on that. It was clear the justices did not buy that at all. I mean, obviously, these books were being used pedagogically and for a purpose. So they're gonna say there's a burden. Now they could stop there and just send it back. But if they get to the strict scrutiny question, then I think things get really interesting because what if the government says, okay, fine, we admit it, we were wrong. There is a burden. But you know what? It satisfies strict scrutiny because we couldn't operate the public schools if we had to give opt outs to everybody. I think they would lose on that too because the unfortunate fact for the government is that they have given opt outs to people in other contexts. So there's no reason they couldn't give them here. Um, so I think the claimants are going to win in Mahmoud, but I think under the surface of the kind of who wins, who loses question, there's this, I think anyway, really interesting question about the status of parental rights. Since they're not written and since a lot of the conservative justices probably aren't big fans of substantive due process, maybe they just talk only about free exercise and kind of shunt off any talk of parental rights.
Yeah. I have so many potential I mean, I'm an extremist on this. The universal school choice option, I think at this point is very plausible, but I'm gonna pass just so we can finish on a couple other topics, and maybe we'll get a chance to talk about this another time. Um,
Extremism in the defense of liberty is no vice.
That's right. Um, so I guess I'll ask one kind of catch-all before we wrap up. I know for people who are watching religious liberty cases, I mean, there's some we passed over that have religious implications, like Planned Parenthood v. Medina and coming out this
Yeah.
and Scrimeti to an extent. For the next term, I know a lot of people are watching this Chiles versus Salazar, the Christian therapist in Colorado. So either I don't know if you don't have to comment on that one, but are there any other cases you think that are either maybe coming up in the next term or that are not yet at the higher courts, but you think are like things to watch in the religious liberty movement in the coming term or 2 or 3?
Well, so the Chiles case that you mentioned is an interesting one. I suspect that'll end up kind of having to do with whether we categorize um, the the regulated activity as speech on the one hand or conduct on the other. Which will be interesting, I suppose. One thing I'm watching actually are these new Ten Commandments laws.
Mm.
So, we had the Kennedy case 2 years ago, the praying football coach case, and a majority told us the endorsement test, that's no longer a thing. And got a lot of people thinking, well, okay, so what exactly is the law now about religion in the public school environment? Um, I'm of the view that Kennedy does not change the school prayer cases, for example, but because Coach Kennedy wasn't involved in curricular activity, it'd be a different thing if it was, a school composed teacher led prayer during class time. I think that would have been a different case. But these Ten Commandments cases, there was one in Louisiana where we actually have a district court ruling, and then I think in Texas, unless events have caught up with me, I think the governor's about to sign a law that requires public school classrooms to post a representation of a version of the Ten Commandments. We have a case from 40 years ago that says that's unconstitutional, but the premises of that 40-year-old case have been perhaps eroded by intervening decisions like American Legion, like Town of Greece, like the Kennedy case. So that's one I'm watching, actually. I mean, it probably won't get to the Supreme Court next year. It'll get to the Fifth Circuit, I suspect, um, within the year. And it'll be an interesting question. A law requiring the depiction of the Ten Commandments, is that permissible now when in 1984 it wasn't? Um, y- you know, Before, back in the 80s, the question we might have asked is, well, is this an unconstitutional endorsement of religion? But that's not the question we ask anymore. So, what is the question we ask? Is it coercive? Well, is it coercive just to have something hanging on the wall? Um, I think the American Legion case suggests that's not true with respect to war memorials. So, is it different if we're talking about the Ten Commandments? Um, we know that a Ten Commandments display on the Texas Capitol grounds was upheld 20 years ago. Is it different if it's in a classroom space? Um, in my own view, the doctrine about religious accommodations and exemptions, I feel like I've got my head around that pretty good. I could tell you what it is. The law about school vouchers and cooperation, I feel like that's come into play pretty well, come into focus pretty well. But what the law is about religious expression in the public square, I think is still not quite settled. We're pretty clear you can't coerce people to engage in religious exercises, but I don't think the court is very interested in kind of policing the kind of epistemological effects, if that's the right word, of having symbols in the public square. And for a long time, as you know, there's been this kind of special solicitude for what happens in public schools because kids are so impressionable and so on. Um, is that still what the court's going to tell us? So that's what I'm watching in the coming year or so, is going to be the post Kennedy law dealing with religious symbols in public context.
Interesting. Yeah, I'll definitely keep that on my radar as well. That's an interesting area, and we'll see how it develops. I there may be more questions in the chat here than we can get to, so I'm going to try to shorten some of them and see what we can do to get through them. So somebody asked about the Washington State mandated reporter law that came out last month. So just briefly for those who haven't followed, that's the mandated reporter law has in Washington has an exception for professionals, right? And their privileged communications, and so like nurses and patients, therapists and patients, but that privilege says except for members of the clergy. So the question here is basically, do you have any thoughts, and will this pass muster as being generally applicable, or is it unconstitutionally discriminatory? I think I have strong opinions, but I want to hear yours.
Well, I suspect ours align. It might be a bit of an exaggeration, but this is one of the most glaringly, obviously unconstitutional things that a government has done that I can remember. Um, it's an interesting question whether a state could say there are no privileges that exempt people from mandatory reporting. Um, I know in the Catholic context, it would still be church law that you'd have to just violate the law. You couldn't. The seal of the confessional is absolute. Um, but to say that all these other privileges still obtain, but we're going to focus on the clergy one, that's just ridiculous. It's kind of embarrassing. I mean, I think Washington is a beautiful state, but someone out there has lost their mind.
Yeah, it looks like it has to be just sending an antagonistic message, because if you really wanted to give the law a chance to survive, there are more subtle ways to do it, to, like, carve out a group that includes clergy and, like, someone else, so it's not so blatantly
Yeah.
discriminatory.
Well, it's it's worse than that though, Frank. It's really pandering to a kind of bigotry, to be honest. And that part of the country has a long record of particularly anti-Catholic bigotry. But um, I mean, it's not even like there's some kind of empirical basis for this special carve out. If there were, maybe it'd be a different case. But um, all the evidence, for example, would be that there's a lot more of these problematic behaviors happening in the public schools than are happening with clergy. So it really does just look like kind of a playing into people's prejudices and fears about the clergy sex abuse scandal, which of course is terrible, um, and using that as an excuse to have this performative singling out. And so I just can't imagine that any court will uphold it.
Yeah. All right, I'm gonna shorten this one a little bit. So, in examining recent church autonomy, ecclesiastical abstention cases that have gone before the Supreme Court, what would you consider as the future of church hiring decisions, church property decisions under a history and tradition analysis? Um, a lot of the controlling cases predate the demise of the entanglement analysis in Kennedy, and it's hard to draw from that opinion what to make of this sea change. So, take that however you'd
Well, this
like.
is a great question. It's one that I'm really interested in. I mean, as I suspect you and the questioner know, we've had two pretty solid opinions on the so-called ministerial exception. I say so-called because I don't think it's limited to ministers, and I don't think it's an exception. But let's put that aside. Um, that really did elevate the status of church autonomy principles, and for me, that was very welcome. So I think that's actually pretty entrenched. We will continue to see cases where there are fights about whether a particular employee counts as a ministerial employee, but the legal principle is pretty well settled. But the church autonomy principle covers more than just the employment relationship, as it sounds like the questioner knows. Um, some of these cases about church property, when there's a breakaway church, when a church community breaks up, when there's a fight over doctrine, who gets the stuff. The law here is very unclear, as it sounds like your questioner knows. Um, I am I'm in the camp of people who like the old 19th century Watson v. Jones approach, which was very deferential to the internal legal structures of churches. So even in contexts where I might be sympathetic to the breakaway um, congregation, like let's say in the context of the American Episcopalian Church, I'm often sympathetic with some of these breakaway groups because, in my view, they're more orthodox. Um, I think the church autonomy principle points pretty squarely to the idea that the church body itself and its own polity and its own juridical structures get to control those disputes. Now, obviously, there are other kinds of religious communities that are organized in different ways, more congregational. Those kind of cases can often be resolved using so-called neutral principles, which is fine. But I would be hesitant to embrace a rule that applied the neutral principles approach to all church property disputes. I think that would be intrusive on church polity. And there's another kind of church autonomy issue, which I think is just fascinating, and people don't often talk about all that much. And that's the whole thing about whether you can have these, whether you can use tort law to go after churches and ministers for like being bad at ministering. Um, Obviously you can sue a pastor if he runs into you with his car. Um, I think you can sue a pastor if he or she physically assaults you and so on. But there have been these interesting cases where um, people have brought like intentional infliction of emotional distress torts against a church because the church made them feel bad. Maybe it like publicly called them out for their bad behavior or something like that. Um, that strikes me as a really, and there isn't any developed constitutional law on this. It's very much a local thing, but there is a sense, you mentioned entanglement, that uh, somewhere still surviving, I think, from the Lemon test is this idea that we really don't want secular decision makers having to get involved in answering religious questions. And in my view, that's what church state separation, properly understood, was always about. It was that we don't let kings pick bishops, and we don't want Constantine to convene a council and tell us what the creed is going to be. Secular courts make secular decisions. Um, and I think some of these tort cases get really close to the line. So I've been keeping an eye on that.
On a similar note, somebody just asked, what are your thoughts on the fraud exceptions to these church autonomy doctrine cases? Like there's the tithing case in Huntsman in the Ninth Circuit that had I forget which judge wrote the concurrence saying this should have been a church autonomy. This it was it Judge Van Dyke?
I thought it
Uh,
was Van Dyke, and I was sympathetic to that.
yeah,
There's a case way back in the early 20th century that kind of planted the seeds for this, and I think it's been tricky where it was kind of like, of course, secular courts can't get involved in resolving religious disputes, and then there's kind of a throwaway line. I think the case is called Gonzalez, um, unless, of course, it was just fraud. And I'm like, no. Um, let's imagine that the bishop of Fort Wayne, South Bend, where I live, who's a great guy and who would never do this. But let's imagine he did this, where he fired a pastor, and they said, "Why did you fire him?" And he said, "Well, I woke up one morning and I just flipped a coin and said, heads he goes, tails he stays." Like, that's not the way you let corporations run their business as a general matter. But the pastor couldn't file a lawsuit, even if the bishop admitted he just flipped a coin. It wouldn't matter, in my view. Now, that's different from, let's say, um, a church enters into an employment contract with somebody and says, "Here's the deal. You're going to be in charge of our landscaping, and we're going to pay you 20,000 bucks a year to take care of the landscaping." And then at the end of the year, they give him only 15,000 bucks, and the guy says, "Well, you owe me 5,000 bucks." The church can't say, "You can't sue us, church autonomy." Like, that's
right.
you can hold people to their bargains. That's not a religious issue. Um, but
I thought
that's as far
the
as the
tithing
fraud thing can go, I think.
I think, yeah, that's it. That's right. And just for those who don't know that Huntsman case, it's interesting because I think the majority decision just they didn't get into the church autonomy question, but the
Right.
concurrence is fascinating because the judge says, well, what is tithing and what's the proper use of tithing funds? And is it reasonable to not tithe if you don't like the way the pastor says something in Mormonism? These are religious questions. Like this is
Yeah.
not just a fraud case in a secular sense. I thought that was
Correct.
compelling.
I did too. I did too.
One more. I think we have time for one more. I want to try to cram this in. So somebody asked, can you speak to why civil rights laws like Title VI generally haven't included prohibitions on discrimination against religion? There's a smattering of such laws specific to certain government-funded programs, but nothing government-wide in government-funded programming. And for those programs that do prohibit discrimination based on religion, do you think there should be any difference in how that prohibition is interpreted as compared to the First Amendment? We've kind of touched on the interplay of statutory definitions a little, but
Yeah. Well, as it sounds like your questioner knows, I mean, public accommodations and civil rights laws are thick on the ground, right? We have federal ones, state ones, county ones, city ones, and they take so many different forms. It's hard to generalize. So, the first point I want to make is that a lot of public accommodations and civil rights laws do include religion as being among the kind of litany of protected classifications and so on, right? Um, and then even, like, let's say Title VII, in the employment context, the federal civil rights law does include religion. Title VI is specifically focused on race. Title IX specifically focused on sex. But it's pretty common to have religion included in the list of prohibited grounds, right? Um, and then, as the questioner indicated, we also have, as a constitutional matter, both coming out of the free exercise clause, cases like Lukumi, you can't discriminate, and also, equal protection, right? Uh, Reasons for thinking that there are constitutional problems with kind of outright religious discrimination. I, my own view, I think I hinted at this earlier, and I realize lots of people would disagree with me on this, is that the statutory, and again, this assumes a functioning legislature, which can sometimes be a problem, but generally speaking, dealing with these things statutorily is, all things considered, preferable, because it's easier to make adjustments and corrections and compromises in the legislative and statutory context than it is once you start constitutionalizing certain lines, right? Now, sometimes it's pretty easy. Carson versus Macon. You can't have a law that says private schools, you get money unless you're religious. That's pretty clear. But a lot of times in these employment contexts or in contracting contexts, it's less clear. Now, the question hinted at a point that I know we're close on time here, but I just want to flag it and then I'll shut up. Um, there's there's one whole conversation we could have about things the government outlaws. Don't discriminate, don't do this. There's a whole other complicated world about the conditions that governments attach to money, right? It's like, oh, you can do whatever you want, but if you take our money, then you have to do X. And I think that in the coming years, the question of the kinds of conditions that can be attached to government benefits is going to be probably the most pressing religious freedom question that we'll see.